All right. So welcome. It's another Hot Topic Tuesday. It is September 26th. And today I want to start out because we got some folks with the exciting news of last week. There's going to be a few joining us that have never been with us before on a Hot Topic Tuesday. And that's our group from Century 21 AAA North. So everybody give them that silent applause kind of thing, right? Welcome aboard if you're with us for the first time. Today, subject matter came up of, and I put it out there. I hope that we don't find ourselves in any of these situations. However, there's a reason that I chose this subject matter. It's because as I'm reviewing documents, I know that that's actually happening. It is going on, some of these things. Some of them you're going to question why they're saying we should or should not do this. So I have pulled this from the attorneys at the MAR Legal Hotline. So I'm going to be doing some bouncing back and forth with this. And all things good, you're going to hear
gears,
what he's got to say.
We're dedicating this letter of the law to some of the common legal mistakes
and I'm not
that
hearing
we
it.
hear
Are you
about
guys?
out in the field and from
Good.
our viewers. While this list is not the product of a scientific or empirical survey, it is based on your feedback and the observations and experience of attorneys who regularly deal with said misunderstandings and mistakes. Let's dive in with some quick-hitting analysis. 1. When a realtor takes a new listing after the expiration of the prior listing with another agent, the realtor should not simply copy the information from the prior listing. Realtors have found themselves in difficult situations when, for example, they have copied the square footage figure from a prior listing and that square footage number has turned out to be incorrect. Realtors should handle the input of relistings in the same manner that they handle any new listing. 2.
So guys, I am literally not hearing what he's got to say, but I've listened to it. So I'm going to do a little bit of a recap. Key is new listings. We have a tendency to go out there and copy from the previous listing. If it was an expired, if it had sold previously, we will simply copy all of the information over from the previous agent, which leaves us. Well, here's one of you. Some of you, if you've been in the business for a while, you remember this. I learned it from a good old friend named Floyd Wickman. Anus, protect us. Now, I see smiles. I know that you get it. See, if we don't verify the information that we did copy over from a previous listing, who's going to be responsible if there is an error? And so we don't want that on ourselves. So let's verify the square footage. Let's go through them and do the room sizes ourselves. Confirm all of the information that's there. Yes. Do I have any problem with copying it over? No, because most of the information is going to be right and it makes it easier. But please, let's go ahead and verify the information ourselves so that we got that correct. Here goes number 2 on this.
Realtors should not mark up an offer and submit it as a counteroffer. There have been any number of disputes arising from a situation where, for example, the listing agent has the seller make various pen changes to the original offer and has the seller initial those changes. The situation becomes more complicated if the buyer then accepts some, but not all, of the seller's changes by initialing those changes, and in addition, makes their own pen changes. Now, when this happens, it may be very difficult to determine the controlling terms of the contract. Realtors should always use addendum forms.
So guys, here's one. This happens all the time, and I don't think that we've ever really thought about what could go wrong. So let me recreate the scenario. We submit a purchase agreement. Seller doesn't like it. They reject it, but they make a counteroffer, and their counteroffer is done by, we'll say, the most common one, crossing out the purchase price, then writing in what they want it to be. They initial it. They make a number of others initial it. send it back. Now, that's not too bad if our buyer were to accept that seller's counteroffer as written. However, what happens if we're okay with parts of it, but we're not okay with other parts of it? Or what if we go okay to all of those, and we add some new changes to that? What is the real offer? What does it actually look like? So the suggestion, and the cleanest way to do it, would be with a simple counteroffer. Our purchase agreement actually allows that to happen. I'm going to pull that up real quick here, all things cooperating with me. If people understand, they could actually just go to the last page and in here specify that they have a counteroffer and simply make the changes there. Guys, with this particular one, quite frankly, we're dealing with a massive, massive issue because this is not just in Metro Detroit where this is done. This is done all over the state of Michigan. When I came over here from Muskegon 30 years ago, I was dumbfounded when I started seeing people crossing out, making initial, all these changes, initialing it. I couldn't understand how that could even happen. So to actually have the MAR attorneys bringing it out that there's a better way to be able to do this. Write a new purchase agreement. Do it correctly as a counteroffer in this situation, or in an event where we have a purchase agreement provided to us where we need to reject and counter, put it on an addendum. Amend it so that the deal stays clean. And about the only thing that we would do in that situation, if it doesn't provide it, is simply put in a little box prior to that says per attached addendum, acceptance per attached addendum. So that everybody now knows there is an addendum you need to look for. The acceptance is per addendum. All right. Let's go back to our letter of the law and number 3 on the list.
Or start with a new purchase agreement form when preparing a counteroffer or a counter to a counteroffer. Number 3, realtors sometimes fail to fill in all the blanks in the purchase agreement form. If a realtor leaves a provision entirely blank, it is often not clear whether the intent was that the provision not apply at all. For example, suppose a purchase agreement form calls for the parties to select one of the following 3 possible tax proration methods. 1, due date in advance. 2, due date in arrears. And 3, calendar year in arrears. If a realtor does not select any of these tax proration methods, does that mean that there will be no tax proration at all? When using a purchase agreement form, realtors shall fill in all of the blanks and cross out the inapplicable paragraphs.
All right. So number 3, filling in all the blanks. Let me share with you what I found to be the most common that we miss with our purchase agreement. It is page 1. And on page 1, what we often do not complete, or we receive offers where this is not complete, is in regards to the cash sale with new mortgage. And either all the blanks are empty or ones that really make a difference. So why is this important for this particular one? It is because it says this agreement is contingent upon securing a blank type of mortgage. That mortgage contingency is that they will get a conventional loan in the amount of 80%. You hear the term LTV, loan to value. I'd like to see that we had that there, but it's not, but that's what it's talking about. So it'd be 80% and 20%. So you see that when the buyer qualifies for that, that contingency is now removed. But if somebody just checks this, but there's no blanks completed, what is it contingent upon? What type of financing? If they ever wanted to get out of it, it'd be pretty easy for them to be able to do. Because they could say, oh, well, we were doing a 50% down, now we don't qualify because we weren't able to qualify for that. Get all the blanks filled in throughout the entire purchase agreement. Don't allow anything that could be interpreted, filled in later, changed, things of that nature. We want to make sure that we fill in all the blanks. Let's go back, and we are now on number 4, dealing with earnest money deposit. As a matter of fact, the next two are on the earnest money deposit.
When a transaction fails, a realtor cannot condition the release of the earnest money deposit upon the parties' execution of a mutual release. If there is no dispute over the earnest money deposit, the realtor cannot use his or her control over the earnest money deposit to force the parties to agree to release the realtor from any liability relating to the transaction. The realtor can, but is not required to, require the parties to sign a release as it relates to the earnest money deposit only.
So guys, I am still winging this a little bit because we can't hear what he's saying. And I don't know why technology does this to us. So number 4, releasing the EMD. We did an actual hot topic Tuesday a number of months ago. I believe we did that this year, in trying to understand how the earnest money deposit is handled when we must hold it and when we must release it. He gave a very simple description as to how or when we must and when we cannot. I would suggest that look back in the HRC Agency Development channel. You'll see previous recording regarding the earnest money, and that gets a very thorough description on how that can be handled. So Lori, yes, on one hand, I would say, looking at the chat room, yes, for other realtors. And can I just put NA? Look, put something in the blank when it doesn't apply. So NA is not applicable, but sometimes it could be a dash. As I always put it, put something in all of the blanks. That's the way that we want to make sure that that happens, so that nobody else can fill something in there and no one know that that is what happened. Okay, let's go on to depositing of the earnest money check.
5. An agent working with a buyer must deliver the earnest money deposit check to his or her broker upon receipt. A broker can wait to deposit the check until there is a binding purchase agreement in place, but a salesperson cannot wait to deliver the check to the broker. Number 6. A realtor
All right, so that's a simple one. State law and company policy requires that when we receive an earnest money deposit, that we deliver it to the office. Company policy says when we receive it, we're going to deposit it. I don't know how else to put it. That's the simple part. You get it, bring it in. But Darwin, the offer hasn't been accepted. It doesn't matter. State law requires we bring it to the office, the broker. As a brokerage, we would have a choice to hold it or deposit it, but our policy is we don't want other people's money floating around in the office. Therefore, we will deposit it. So just know that I want to again point out the aspect of clauses in the earnest money deposit. Let me go back to page 1 here. We're going to state that we've got the earnest money deposit. We always know that get a reasonable amount. My thought is always a minimum of 1%. Minimum. We are not going to sign this unless if we have actually received it, because this is saying acknowledgement of the earnest money deposit, it's received by. If we have it in hand, we sign this. However, we do have the option, I think everybody knows, page 4 of the agreement. Come on, there we go. We can do this. And in here, we can add a clause which will give us the additional time, seller agreeing. Come on. Can't get close enough to do it. Add a clause. Oh, there it is. That's why. In the clause libraries, this is both for the blue and the gold. We have the main library, and here it is in this particular library. It's right up front. Earnest money deposit within days of acceptance. And this is the one, if you're going to use this technique, it's the one that I prefer that you use so that we don't forget to collect the earnest money deposit. So I'll tell you what, it's tricky when you're sharing to get this to fully function for you. Here we go, and it will drop it right into that paragraph. And it says that it will be deposited within 5 days of receipt of seller's acceptance. And that's the technical part of what the earnest money deposit rules are for that. So they know that that is an option for you to do when it comes to the earnest money deposit. And we're back. Let me get this guy back out of the way for us. Number 6. Oh, yes. Not common at all, but this one's kind of interesting because I want you to see it. He's going to address key submitting simultaneous counteroffers. Keyword simultaneous.
Should be very careful to make sure that he or she does not make any steps that could result in a situation where more than one buyer claims to have a binding purchase agreement. Any number of disputes have arisen where, for example, after a seller has received multiple offers, the listing realtor prepares multiple counteroffers and delivers them simultaneously to all of the buyer's agents with the message that these are the terms the sellers will accept. Now, a listing agent who does this runs the very serious risk that more than one buyer will accept the seller's counteroffer.
Okay, so I think this one's pretty clear. If you think about it, let's say we got 4 buyers, came all in on 1, 2, 3 easy straight. None of the offers were acceptable to the seller. My camera is going to change here in a moment. At least fingers crossed it will. If those are all in writing, then we have an issue. Because all it would take is for 2 of the buyers to decide that they will accept the counteroffer. And you've now sold the house twice. Could be up to 3 or 4 times, should we not do this correctly. So I want you to think about that. We do not want to make multiple written counter offers. What we would do is we are rejecting your offers as they were written. And we would state, here is the seller's terms. What would I even prefer more? That they choose the one that would have the best financial terms. As an example, there is one which is cash, one which is conventional with 20% down, one is a conventional with 3% down, one is FHA, 3.5% down. There would be one pretty clear choice out of that, right? Let's see if we can make a counter offer to the cash buyer under the terms that we would want and work with that individual. Bottom line, if you get multiple offers and you're a little bit lost what to do, involve your manager in those negotiations. Let's talk number 7.
Number 7.
This is an interesting one,
Realtors
guys. We're going
working
to end
with
up talking more
buyers
about this.
sometimes rely solely on the offer of compensation through the MLS. This can be risky. Realtors working with buyers need to protect themselves by entering into buyers' agency contracts. This is so important, especially in today's climate. If they do not do so, they may end up not being paid. Suppose, for example,
Let me pause for just a second. Again, I apologize. We're not hearing what he's saying. I don't know what technology did to me. Realtors working with buyers sometimes rely solely on the offer of compensation through the MLS. Why is that risky? Well, he's bringing that down. But the key is if we get the offer of compensation through the MLS, we will be paid by the cooperating broker what they have offered as compensation. The risk comes in with what he's going to propose here. So what I want to say is we're okay. We don't have to worry about getting our compensation if it's coming through the MLS. Now, stuff happens. But when it's marketed, showing that a buyer's agent will get 3%, 2.5%, whatever it is they're offering, you're going to get paid. But you won't have the opportunity to be able to collect what you actually want if they offer less or if they offer 0. And guys, I'm going to tell you that with what I know of from recent settlements with RE/MAX and others, it's coming. We need to make sure that we've got these taken care of. Here's the rest of it.
Realtor A has worked with Buyer Smith for many months. Buyer Smith has narrowed the choice down to 3 homes. Then, out of the blue, Buyer Smith purchased an entirely different home through Realtor B. Realtor A will not be paid, as he or she is not the procuring cause of the transaction that closed. Number 8.
So the bottom line to the buyer agency contract, guys, let me go back. Whoops. Get the right one to share here. Bum, 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 bum. I don't want to show you that one yet. Let me get you. You'll find in our library too what I believe will become a necessity as we continue to move forward will be that we move to a long form. Let me explain why. We have a very brief single-page form right now for our buyer representation contract. So as we move forward, you're probably going to want something which is more detailed. I'm not going to go too much into this, but this will basically ensure your ability to be able to collect a commission regardless of the situation. All right. So this is the MAR, the current MAR buyer representation agreement with some interesting details to the commission and the compensation, because not only what if they buy through the MLS, but what if you find one that's not even on the market? What if they find one that's a for sale by owner? How are you to be compensated? But even with our current short form, we are covered, because if we complete it, guys, and we put our percentage in here, we do have something to stand for. And most everyone knows Rick Linnell. Rick Linnell has confirmed, should you ever have earned your compensation and the buyer tried to cut you out of it, this is worth very much the paper that it's written on. Matter of fact, it's worth 3% of whatever they ended up purchasing if they breached our buyer representation contract. Okay, let me go back. So question came up here, guys. When would that potentially happen? Most likely it would be in the, well, with the scenario that he brought up to us. We've been working with this buyer. We've got them under contract. We properly disclosed. They were still in terms of the contract. And they went out, lo and behold, went out and bought a house from a different real estate agent. They went out and they bought a for sale by owner. They just cut you out of it. Because remember, the compensation offered in the MLS is from the listing broker. That doesn't deal with the compensation owed by the buyer, except that we accept whatever the listing broker pays us as compensation gets credited toward what they owe us. So if they go buy a house from somebody else, that broker is going to compensate the broker that they know brought the buyer. We got left high and dry because they don't even know that we were involved, that a buyer representation contract was there. Therefore, our only recourse is really not, everybody always says, well, procuring cause. No, we didn't introduce them to that property. Some other agent did. Procuring cause deals with the compensation offered from the listing broker. So we're really talking action against the buyer. And the only way that we can do that with a properly completed purchase agreement, or excuse me, exclusive right to sell agreement. Let me hit number 8.
Realtors must remember that the submission of a proposed amendment to the contract does not in fact enable the recipient to cancel the existing contract. Suppose, for example, Realtor A lists 122 Elm Street and an offer is submitted and accepted by that seller. During the time of the financing contingency, the buyer submits a proposed addendum to Realtor A, asking for an extension of the time to close. Now, Realtor A declares.
So guys, this is one that actually does happen a lot, and it's because of the ignorance of real estate agents. They think they know, when in reality, they have no idea. So you need to know beyond a shadow of a doubt that once you have an accepted purchase agreement, that a proposed addendum or amendment of the contract does not kill the deal. They cannot just go, oh, okay, you want to change it, therefore it's dead. Nope. Because the contract is in place. My proposed change doesn't change that contract until a seller signs it. If a seller doesn't sign it, then that purchase contract, that purchase agreement is still in place. Don't allow anybody to think that they are in control simply because we've made a proposal. All right? I believe we're on number 9.
Declares the addendum to be a counteroffer, which the seller rejects, and then accepts a better offer from another buyer waiting in the wings. The house has now been sold twice. Number 9. If a realtor represents that a property is serviced by public sewer and water, and that ends up not to be true, the buyers may be very unhappy. This is particularly the case if, for example, the septic drain field is saturated and the nearest public sewer is $20,000 away. Realtors who are not familiar with the area in which a home is located should confirm the existence of a public sewer by calling the municipality and/or asking for a copy of the seller's water or sewer bill. Number 10, and finally, realtor.
So guys, that one, it happens. It happens really in two ways. One, when we go into an area where we're not familiar with. Two, when we just don't verify. So if you ever question if there's anything that gives you any hints, if you see green covers at about, we'll call it what, Don, 18 to 24 inches in diameter, that's a good hint that there's a septic system there. Now, those don't exist in every property, but there's things that you want to look for. When in doubt, you should confirm that those are in there. And by the way, that goes for both as a listing agent and as a buyer's agent. Either way, we could be held responsible, and we don't want to be in that situation. And remember this, they may have municipal water. Matter of fact, we just had one that we've completed where it is municipal water, but it's a septic tank. This is in Shelby Township, where you'd go, what do you mean it's on a septic system? It's kind of a shocker. But good part of Macomb County, it's required that a septic be inspected. So we're going to be safe. All right, running a tad bit over, but here's our last one. This one's simple too.
Realtors should take great care to date all documents. Purchase agreements are typically full of terms that must be performed by a specific date, which is most often calculated from the date the contract becomes binding. For this reason, it is very important that all signatures are dated. Well, that is it for today. Thanks for watching.
Anyway, that's pretty much it. He's going to promote stuff from there on. So date the purchase agreement. Date the signatures. Make sure those are there and accompanying the signature. You see, it's one of the things that we do to be able to provide or prove that we have a binding contract, that there's been a meeting of the minds. And that is when notice of acceptance has been received. Well, the best way to be able to prove that is through a signature with a date. Guys, there's other things that I know are out there that could come up. And as they do, we'll have more hot topics about what is going on. Let me check the chat here to see if there is anything else that we've got. Can we write a PA EMD upon acceptance? Yeah, and actually, Darlene, we'll be working with the AAA group to make sure that transaction desk is set up for them, and also for Remind Docs Plus. We'll have a full set of those in there, but that would be one that we can do. Can we write a PA, a EMD upon acceptance? Absolutely. We just want to make sure that we use the proper language for being able to do that. Know that, yeah, Laura, great reminder. EMDs can be wired. Now, there's a minor fee for that, but EMDs can be wired. Those with AAA, that will be getting set up. Let's see. Last one I've got here. What about a situation where the agency agreement says 3% compensation, but the house we are buying is a 2.5%? I assume we get the lower of the two. What about a situation says, okay, your agency agreement says 3%, compensation on the house is 2.5%. So I'm going to hit this one fairly quickly, Kevin, but don't be afraid to give me a call or talk with your manager. But the way that, should you choose to do this, and again, I'm predicting in the future, we're going to see where we're going to go after what our full commission is. We have been accepting over all these years whatever the compensation is offered from. But if we sign a buyer up at 3%, we contractually can collect that 3%. The way that we would do that is we're going to take the 2.5% from the listing broker, and the buyer would be responsible for paying that additional 0.5%. Now, how they do that, they could pull out of their pocket. I almost hate to say this right now because we don't have enough time to cover it in detail, but they could ask the seller to pay the other 0.5%. We cannot ask the listing broker to pay that additional 0.5%. We cannot ask the listing broker for that other 0.5%, but the buyer through their purchase agreement could ask for that other 0.5%. But yes, if we have that in place, then we would be able to do that. Yeah, so another thing that you could have happen with EMD, it can be held by the title company. It could be held by anybody. However, the key is that if it's held by anybody other than the broker who has received it, it must be stated in the purchase agreement. So that's number one, a way around it. Have somebody else hold it, state it in the purchase agreement. Title companies do this all the time. The other thing that you may run into, if they've written a personal check, it could take up to 10 days for that check to clear. So know that, because in that non-interest bearing trust account that we have as a broker, we have everybody else's money, not ours. So we have to make sure that that's in the bank before we release it. And yeah, 10 business days is what to look for. Potentially, by the way, it could be less. We can confirm that it has been cleared. We can release that in less time. Let me see what else we got here. Carolyn, you did say we can write up a new agency agreement. Well, our company policy still says 3%. So we want to write up our buyer agency contracts at 3% plus. So be it 3%, 4%, 5%. If you look, Carolyn, you have this available. Look at the MAR Form JJ, buyer representation contract. Go to the last page and you'll see again some interesting verbiage that I've introduced before that may or may not make sense as to why we're doing that. But yeah, we're still a minimum 3% on that. And then any shortfall, such as 2.5% offered by a listing broker, the buyer would be responsible for paying that. By the way, always have been. It's just most of the time we accept the compensation offered by the listing broker as full compensation. So back up, Kevin, by the way, yeah, typically it is the less, but again, we do have the right to pursue that additional shortfall. Guys, I think that is it. So a little overdue on the time at 12:38 here, but I hope this was one that you enjoyed, that you got a lot from it. If you have questions, you know I'm always available. And this typically is added to the HRC Agent Development channel before the end of the day. So if you want a review of it, it will be there for you. We'll run it from there. I hope you all have a great one. That's the end of another Hot Topic Tuesday. We'll see you next week, guys. Bye-bye.